Courtrooms aren't always about justice served on a silver platter. Sometimes it's more like microwaved left.
You're in the center and your attorney's on this side. So you're Eric Cepeda?
We're barely 10 seconds in and already the stakes are clear. This isn't a glossy TV courtroom where justice is plated up neatly. This is real life. Teenagers, ankle monitors, and bills they can't afford. Ever wonder how freedom can cost $300 a month?
I'll need to take some testimony.
They are recommending $10,000 bond, Your Honor. I believe the original amount when Mr. Chartea was originally arrested was $5,000.
These real-life cases expose the messy, emotional chaos behind the gavel. Who got a slap on the wrist, who got a reality check, and who's still waiting for the other shoe to drop. A waiting game as the state delays contacting the complaining judge, leaving a defendant in limbo over probation termination.
Hi, good morning.
So
here's the thing. I understand that sometimes with the nature of the case that the state will not agree to early termination. But at the end of the day, the reason why I have defendants come in when they want early termination is because
when I can get it this afternoon, that's how interested I am.
if you just check boxes on the courses that I've given you, or if you really internalize. And what I can tell you is you are the first person who's come before me with this type of case and said
Okay,
that
but who should I
you
contact?
didn't realize that the certain tone you use in your voice, that you shouldn't use that. So
Okay,
you've successfully completed everything. Probation at the last hearing said you had successfully completed everything, but because of the nature of your case, I wanted the complainant to know that the court was going to grant early termination. So I told you then that whether or not the early termination is signed off today was completely in your hands. If you followed everything and didn't violate any conditions and continued on probation, then I would sign it. So probation has told me that none of that happened, that you've done great. The state has informed me that the complainant has been contacted, so I'm going to grant your motion for early termination. You're welcome. And counsel, I'll sign I'll sign probation. They have a form for me to sign for early termination, so that will be signed.
We had requested both early termination and a dismissal.
yeah, I'll try. I don't have much this morning.
I'm not going to do the dismissal.
All right, thank you.
And I will tell you that not allowing you the dismissal is based upon all the evidence that I've heard. That's the reason why. Okay? It's, in some cases, I have allowed it, but I'm not going to allow it in this case. But I will do the early termination. I'll stay here for a minute.
My only point is that he has been on this for a long time, like we think roughly 7 years under court supervision, and he's done everything, and this would be like a better way.
Here's a key procedural nugget. Early termination of probation isn't automatic. Judges often leave it dangling like a carrot. Complete every requirement, stay clean, and maybe, just maybe, you'll earn it. But one slip, and the deal evaporates.
Coming to court every time.
So I'm not inclined to grant that. If you want to confer with the state and see if they would be in agreement to that, I'll consider it. But at this point, I'm not inclined to grant that.
Well, we appreciate the court's consideration, Your Honor. And I will, Mr. Harris still around?
I think he's stepped in the hallway. But what I'll do is I'm going to sign the early termination that probation is going to provide. And if you want a copy of that, they'll give you a copy of that. Just remain in the courtroom.
Okay.
All right.
Thank you, Your Honor.
You're welcome. Thank you so much.
He's 17, broke, and facing $300 a month just to stay out of jail. His request, ditch the GPS fees so he can maybe afford to live. Freedom really isn't free, huh?
All right. Hello. You're in the center and your attorney's on this side.
Good.
So you're Eric Cepeda?
Yes, ma'am.
All right. Thank you for dressing appropriately for court. All right. So defense, I have this motion to reduce bond. Of course, that's
just waive fees. The reduced bond was, I forgot to cross it off on the original copy. It's just waive fees.
all right. So it's the waive fees of the GPS?
Yes, Judge. That's all we're asking.
All right. So with regards to waiving the fees of the GPS, because he's not in custody, I'll need to take some testimony.
Okay.
And Mr. Cepeda, that testimony will solely be related to your ability to pay the GPS fees. Do you understand?
Yes, ma'am.
All right. And Cindy, let us know when you're ready.
Okay. I should be okay for now. I mean,
Okay.
I have 1 minute, Judge.
Sure.
Let me talk to you 1 second.
All right, sure. Hi, how you doing?
still are you?
All right.
I'll tender to the court. I crossed out the reduced bond everywhere except the title, so I don't know.
That we filed in the motion and all
Oh,
that stuff.
Oh, let me just tell you, I don't even have any of that. This is the only
okay.
thing that I have.
Perfect. Yeah,
Okay.
all that, we don't.
So
need
we'll
to
go
do-
with this.
Yeah, that's, except for the motion to reduce.
Okay.
You want to do it?
So just, is it working now? Steve?
Yeah, I'm good.
Oh, okay, it's working. Do you
Well,
still need
there's-
IT or no?
Yes, there's a couple of them that aren't working, but one's working for now for you to do this.
All right, this should take 5 minutes. Or maybe 8. All right, the court is calling 2025 PF 07201, State versus Eric Ray Cepeda. Can I have parties announced for the record? State?
I'm sorry, Judge. Jason Garahan for the state.
Good morning, Your Honor. Daniel Del Garza and Charles Bunk for the defendant.
And are you Mr. Cepeda?
Yes, ma'am.
All right, so defense, you did have a motion to reduce bond. That's moot because your client has made bond.
Yes, Your Honor.
So now you're before the court and you're asking that
Pause for a second. Notice how the defense walks the 17-year-old through a checklist of 0 income, 0 assets, 0 everything. That's not filler. It's building a legal record to prove indigency so the judge can waive GPS fees. Think of it as courtroom chess. Every answer a move.
All right, you can lower your hand, state your name for the record.
Say it right now.
You may lower your hand, state your name for the record.
Eric Cepeda.
All right, so this hearing is solely to determine whether or not you're able to pay your GPS fees. Do you understand?
Yes, ma'am.
All right, defense, you may ask your questions.
Thank you, Your Honor. Good morning, sir. And you're the defendant in this case, right? Okay. And just let me ask you, you are on bond in this case, right?
Yes.
And are you wearing a ankle monitor?
Yes.
It's a GPS monitor, right?
Yes, sir.
And there are fees associated with that monthly, is that right?
Yes, sir.
And are they $300 a month?
Yes, sir.
And are you working right now?
No, sir.
Were you working at the time
No, sir.
that you were arrested?
No, sir.
And do you own any stocks or bonds?
No, sir.
Do you own any real estate?
No, sir.
Do you own a car?
No, sir.
Do you own anything of value that can be sold?
No, sir.
Do you live with your parents right now?
Yes, sir.
Are you on full house arrest?
Yes, sir.
And do you solely rely on your parents for shelter
Yes, sir.
and food
Yes, sir.
and monthly expenses?
Yes, sir.
I'll pass the witness, Your Honor.
Any questions?
No questions from the state, Your Honor.
All right, I just have a few questions. When were you released from custody? Defense, do you know when he was released? Just approximately.
About a week, Judge.
And how old are you?
17, ma'am.
All right. All right, and you're on full house arrest.
Yes, ma'am.
And since you released, have you tried to seek employment over the internet or anything of that nature?
No, ma'am.
Okay. And have you previously been employed?
No, ma'am.
All right. Then if there is no other testimony, the court is going to grant the motion to waive GPS fees. All right. Any other motions?
That's all we have on this issue.
All right. So, of course, this case has not been indicted. And the reason why I said it is because of the nature of the case. I wanted to make sure, and I know with the attorneys that are on each of the defendants' cases, there will be communication, but I wanted to make sure if there's any issues with downloading anything such as videos, or if there's going to be a cell phone dump, we can go off the record that communication is constantly open. So, defense, if there's any type of issue with something you can't download, please, I know you all wouldn't, but please don't wait till the last minute to say, I can't download this.
No, Your Honor. No, we've both known Mr. Garahan a long time. I'm pretty sure we even have his phone number. So if there's any issues like that, I'll text him or call him. And what I typically do on these cases is I just bring them a big old drive from Costco with 4 terabytes or whatever. And I just ask them to throw everything on there. And if there's anything that needs to be supplemented, and I did this as recently as this week. then I'll bring them another drive or I'll download it from eDiscovery. But
Okay.
I'll make sure that there's no issues.
All right. And Mr. Cepeda, I'm not the one who set the bond in either of these cases. But what I want to tell you is sometimes with the GPS, people will say, my battery is running low or something's wrong with the GPS. You need to stay in contact with your pretrial services officer. And if there's an issue with the GPS, you need to let them know beforehand there's an issue. Because if I receive pretrial services notices that they've lost contact with your GPS because of the nature of your offense, I'm going to sign it, and then we can have a hearing later, of course, about what happened, but don't let it get to that point. You understand?
Yes, ma'am.
All right, so this is what I'm going to do on this case. I'm going to reset it for May. So if you all can look on a date in late May that is good for everyone. And again, it's just to see where we are, to make sure information is still flowing, which I know it will, but I just don't like cases to be out there and nobody's had real contact, okay?
Yes, Judge.
So just let me know what date would be good for all parties. And Jason, I know you have capital murders that are already pending in murder cases, so if May is not a good date to bring this back, if June would be better, just let the court know. And guys, since this is a case where it's 3 co-defendants, and that really puts a strains on the deputies because they have to keep them separated. Deputy Laura, I'm sure Friday would probably be best, or Wednesday. Friday or Wednesday, as opposed to bringing them on a Thursday or Tuesday where there are a lot of people.
Judge, instead of Wednesday or Friday.
21?
Well, 121.
21.
Okay, that's good.
May the 21st, Judge.
All right. So, Ms. Ferguson, this is going to be called for May 21st. And we'll just set it as a discovery.
Excellent.
All right. Is there anything else from either side?
Not from the state, Judge.
No, Your Honor.
Do you have any questions about anything?
No, ma'am.
All right. Once you sign the reset form, you'll be excused. All right. Thank you. Thank you.
Discovery issues, lawyer drama, and a detective who may or may not hold the keys to a conviction. It's like a legal soap opera, except someone could actually go to prison.
All right. Hello, Mr. Cox.
Ma'am.
All right. So,
And there's the gut punch moment. The judge isn't just sentencing, she's giving a reality check. Do you want to die in a field or get clean? It's harsh, but it's also a rare glimpse of judicial humanity, where legal process meets street-level truth.
just set them with the coordinator and we will hear it. I'm trying to keep these cases on Wednesdays and Fridays because it's hard for the deputies when we have a full docket and then there are certain inmates that need to be separated. So we've decided previously to bring this back on May 21st. Are you available with that date?
Yes, sir.
All right, so we'll bring this one back on May 21st as well. You may need a hard drive. I don't know if there are phone dumps in this case or not, but I'm sure there will be a lot of evidence.
Let you know, Judge. Yes, there is.
All right.
And
So,
just for the record there, on the my IT person,
Mhm.
Angel checked, and the only thing they had, the only have discovered that appeared in the online for us, the portal, is the arrest affidavit. So,
Mhm.
so I've gotten nothing other than the arrest affidavit. So I don't know how quickly those things are going to be.
I checked out yesterday, and at least I don't remember which one I looked up, but I mean, we do have reports on there. That's I made copies of that. So if you would like to bring a hard drive, I mean, I could get at least, or I can make a copy of the sort of the packet of the prosecution, the detective handling it. It's out of Selma, Judge, so it's a little different. But I mean, I can supply
Okay.
that to you if you like.
That's fine.
all right. And if there are some issues with discovery, as I was telling the other attorney, I know the attorneys on this case, so I knew you all would communicate. But if there's some issue that discovery is not being delivered from Selma or wherever it may be, that's what we'll be having these hearings for, to make sure everything is
That's fine.
going well with discovery. So we're going to be back on May 21st. Mr. Camarel, do you have any questions? All right, so we'll bring you back on May 21st. And Mr. Cox, if there are any motions that you wish to have heard, just let the coordinator know.
Thank you.
And we'll put it on the docket.
Thank you, Jim.
Thank you.
Drug plea deal turns into a life or death warning. Do you want to die in a field or get clean?
State versus Nicholas Cameron. Can I have parties announced for the record?
State.
Scott Hill for Mr. Cameron.
Are you Mr. Cameron?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Cameron, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, waiving the habitual offender enhancement allegation.
Any objection?
No, Your Honor.
Did you review admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes,
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Cameron, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Sure.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea bargain agreement, punishment must be assessed at 180 days in the Bexar County Jail under 1244, and there are no applications. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
No.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Judge.
Then to the offenses charged, how do you plead?
No contest.
State any evidence.
Should be contained in Exhibit 1 and attachments, Judge.
No objections.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I've spent a lot of time talking to Mr. Cameron, just trying to give him some counsel on some programs he can try to go after he's released from Bexar County Jail. He is going to go stay with his mom, who's here out in Elmendorf.
Yes.
Elmendorf. Judge, he's been in custody for, I don't know the exact day, but it's been over probably 7 months.
9 months.
I don't think it's quite 9.
His next part flips the script. Gabriel isn't the accused aggressor, he's a stabbing victim, now caught in his own legal spiral. Trauma, therapy bills, and bond.
And he knows that's an issue for him, so he's going to do his best. So I'm just asking the court to follow our plea bargain.
All right. The court will find you guilty as previously stated, sentence you to 180 days in the Bexar County Jail under 1244. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Sure.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, we can go off the record. How old are you?
41.
All right, so here's the thing. You're getting to that point where time is going to go by so quickly for you, and you're going to have to start making decisions. Do you want to spend a majority of your time in jail or in prison? That's completely up to you. It's obvious that you have a drug problem. If you don't get that resolved, what's going to end up happening is either you're going to end up in jail or somebody's going to end up identifying your body. And I don't think you want your mom to have to be the person to have to identify your body in some field somewhere. You understand? But at the same point, if you're not prepared to live life truthfully and openly, where you're trying to improve yourself by becoming clean and sober, then don't visit that on your mother's doorstep. Just send her letters. If you want to be dishonest and say, Mom, I'm doing great, then do that. But don't let her have to see you continue to use over and over, because then that's burdening her, because she has to provide tough love for you, which usually mothers don't want to do. When they see their child hungry or they're not doing well, then a good mother, then they're not doing well if their children are not doing well. So you're going to have to make decisions. There are plenty of programs in San Antonio. There are plenty of programs in Elmendorf that can help you. But in order for you to be successful, you're going to have to change people, places, and things. And the only thing you should be doing is going to work and going home, and nothing in between, unless it's sober support meetings or some kind of treatment. You understand?
Yes, ma'am.
All right. Good luck to you. Okay.
Okay, thank you.
You're welcome.
Have a good day.
You too.
Thank you, Judge. May I be excused?
Yeah.
A stabbing victim's mental health crisis leads to a $10,000 bond. But will trauma derail his second chance?
Is calling 2024 CR 1497 State versus Gabriel Paul Echatia. Am I pronouncing your last name correctly?
Yes, ma'am.
All right, thank you. Oh my gosh, that's shocking for me. Okay. Could I have parties announce state
Andrew Harris, Salem.
defense?
Jesse Sepulveda for Gabriel Paul Echartea.
And if you could state your name for the record, sir.
Gabriel Paul, he's right there.
All right. So your client is appearing by Zoom. Any objection to us having this hearing with your client by Zoom?
No objection, Your Honor.
All right. Your defense counsel has filed a motion to set bond in this court, the 187th District Court. You're on deferred adjudication, so you're entitled to a bond. The only question is what the amount will be. Have you all discussed an agreement with regards to a bond?
I discussed it with Mr. Edelman as well as Jason Garahan, and they are recommending $10,000 bond, Your Honor. I believe the original amount when Mr. Echartea was originally arrested was $5,000.
All right. And the court, due to the fact that your client is on deferred adjudication out of this court, the court is aware of any type of prior substance abuse issues. But there are a few questions I would like to ask you with regards to your status now. If you could raise your right hand for me, please. Yes. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, and if you'll state your name for the record again, please.
Gabriel Paul, he's right there.
All right. How long have you been in custody in the other county?
About a week, ma'am.
All right. Since that time in custody, have you been placed on any type of mental health division of that jail?
No, ma'am, but they have requested and asked me if I would like to, and I denied.
All right. And so you're not on any type of medication?
No, ma'am.
All right. Then what the court will do, the court will follow your agreed bond recommendation of $10,000. I'm going to order sober support meetings as a condition of your bond, and I'm going to require 30 days. And then we are going to set this for a hearing. We can go off the record. State, what is the status of the allegations in the motion? I think there is a number 1 with regards to reckless driving, and it's in Bear County. Would you have that police report?
No, Judge.
All right.
I might be able to look it up if you'll allow me to.
Yes. I just want to make sure that you have what's needed, and then I can give you all a setting.
Thank you, Judge.
And is he only there because of the warrant here?
I believe so. Is that right, Gabriel?
Yes, sir. And yes, ma'am.
Okay.
Judge, if I may, I was just retained a few days ago, but from what his mother has told me and his brother told me, apparently Gabriel was a complainant on a case. He was stabbed 4 times by some other individual, I think a boyfriend of one of his ex-girlfriends. And I'd like to, I guess, just be given some time to inquire about that, because she says he's not the same individual, that he's had some issues afterwards, and I'm not sure if he's seen a psychologist or psychiatrist, but apparently it was a traumatic event for him.
Okay.
Is that right, Gabriel?
Yes, sir. I haven't seen a psychiatrist or a psychologist after the stabbing or anything. They recommended therapy through the state. The state was providing it, but after a while they started charging, so I couldn't afford it.
And then, Ms. Ferguson, if you can bring this back the week of April 14th. Right. So
I think I had something in the juvenile on April 15th. On that same week, 14th. Yeah, can we do that?
all right. So your case is going to be recalled for April 14th. You should be released. If you are released, you need to be here at 9 a.m. Do you understand?
Yes, ma'am, I understand.
All right. Is there anything else, counsel?
No, Your Honor. Thank you.
All right. Thank you.
And be excused.
Yes, you may be excused.
Good week.
All right. And sir, you can let the deputy know that your hearing is complete. Your attorney will probably get in touch with you or get in touch with your family to see about your release.
All righty. Thank you, ma'am. I will.
All right. You're welcome.